Hello, everyone. This is Howie Mann speaking. I'm the Senior International Law Advisor with IISD, and it's my pleasure to host this webinar today. On behalf of IISD and our partners, I want to thank everybody for joining us. I hope you can all hear us. Slide, please, Sophia. What we're going to talk about today is the issue of private partnerships, PPPs, and in particular, the legal contracts that are used to support PPPs. There's no doubt that building and accessing infrastructure is a critical issue today. Infrastructure is a critical need for sustainable development, but it's also true that how we spend the money on infrastructure is itself a critical driver for sustainable development. And we'll be looking at those two linkages to some extent today. Slide, please. The key issue for today is how those linkages are reflected in the actual PPP contracts. So we'll look primarily at what is in the current model contracts, in particular those proposed by the World Bank and to some extent UNCTAD and others at the multilateral level, and focus primarily on the clauses that have been introduced so far. But at the same time, it's incredibly important to note what hasn't been included in those provisions to date, despite numerous efforts by some governments and civil society organizations to get them included. And that's an indication or clear linkages in the contract provisions to ensure that infrastructure makes a maximum contribution itself to promoting sustainable development. That includes the broader range of SDGs, Sustainable Development Goals, and it includes major issues relating to climate change, including resilience to weather events, and making sure that new energy and other sources of potential GHG emissions, greenhouse gas emissions, are mitigated to the maximum extent possible. Those issues have not been reflected to date in what we see proposed at the multilateral level. Slide, please. What we've put up here is just a reference back to a document that Martin Brauch of IISD produced a couple of years ago on what elements need to be included in infrastructure contracts for them to reflect those types of linkages. So I encourage everyone at some point, everyone who hasn't looked at this document, to go back to it as well. Slide, please. I'd like to welcome our three speakers today. The first one is Beatrice Florence Ikilai, who is Vice Chair of the UN Economic Commission for Europe Working Party on PPPs, and is the team leader on PPPs in the Ministry of Finance, Planning and Economic Development for Uganda. And she'll give a perspective on PPP issues from her role in that context. The second speaker will be Motoko Azawa, who is the coordinator for the Observatory of Sustainable Infrastructure. Motoko's experience in this area goes back a few decades with work both in the private sector and at the IFC, International Finance Corporation, part of the World Bank. And she's one of the world's leading experts on business and human rights issues also. And finally, Janice Brennan is of counsel at Foley Hoag, one of the leading American and international law firms, and a firm that is very, very well known for representing and reflecting, in particular, developing country interests on major international development concerns. So with that, let me go first to Beatrice and give the floor to you, please, Beatrice. Oh, sorry, I have one more thing to do. If I can come back, if we can go back one slide. Thank you. Sorry about that. We will be having a Q&A session immediately after the presentation. We invite you to use the chat function that's at the bottom of your screen. If hopefully you're on a computer. If you just scroll down or use your mouse to go down to the bottom of the screen, you'll see a chat function. You can enter your questions there, and then we can come back to them at the end of all the presentations. Okay, and now back to Beatrice, please.
Oh, thank you very much. I didn't get your names.
I'm Howie Mann.
Howard Mann, thank you very much for that wonderful introduction. Good afternoon, everyone. I'm sorry I'm late because I thought the teleconference was at 3 Ugandan time. So I think it was 3 Geneva time. So I'm sorry I'm late, but to set the ball rolling, good evening, Yanni, Brennan, and Motoko, and everybody who is there. My name is Beatrice Flora Ikilai, the Vice Chair on the United Nations Economic Commission for Europe. And I am a certified public-private partnership expert from Harvard University. Had training from University of Queensland in Australia. I've had training in University of Queens in Canada. I have been to University of Pretoria in South Africa. I've been to Infrastructure UK, just to understand public-private partnerships. So from where I sit, I happen to be the pioneer director of the public-private partnership unit of the government of Uganda, where I was responsible for the establishment of the policy, legal, regulatory, and institutional framework for the PPPs in my country. And we also undertook a country diagnostic study, 2 country diagnostic studies, purposely to understand government's readiness to do public-private partnerships. We also undertook development of a PPP pipeline, basically to ensure that we have an investment tool or a pool of projects that we can use to attract the private sector players into the PPP space. Back to what you want me to talk about, PPPs, especially from the less developed countries' perspective, and give a focus of Uganda. A couple of challenges. The key challenge is ability to understand exactly what PPPs are. So you find in a room, I might be the only one or with another person closer to me who is able to understand what I am talking about in terms of public-private partnerships, because several people have different perspectives on what they believe is public-private partnerships. So the aspect of capacity to understand, first of all, the structuring of PPPs, capacity to understand the legal implications of PPPs, capacities to understand the financing of PPPs and what kind of projects should be done as PPPs is a big thing in Africa, because PPPs is not something which is a straightforward animal. So it needs to be understood. To follow up on that, at the UNECE, I got appointed last year as the vice chair on the UNECE, and one of the key things that I have done is to organize a high-level event, which is public-private partnerships, Africa's next big thing. Because from my past experience, I realized that actually many governments, even the presidents, don't understand exactly what PPPs are, including the ministers who are actually responsible for infrastructure development. So in this event, we are going to be having a pre-conference training, basically to bring people up to speed with the public-private partnerships and a few jargons in public-private partnerships. But we're also going to talk about bridging infrastructure gap. African Development Bank estimates that, first of all, says that Africa is a nice continent with very good natural resources, very good people, but it agonizes with infrastructure challenges. Either there's limited infrastructure or there's no infrastructure at all. and it estimates that infrastructure gap is between 130 to 170 billion dollars per annum, and the financing is between 68 and 108 billion dollars per annum. So there's a gap. So they are saying, how do you fill this gap? So the conference will be focusing on how to fill the infrastructure gap, but also how to fill the financing gap. But the discussion also will be around whether people actually understand what PPPs involve, the different clauses in different PPP contracts, and why those clauses are in the contracts, and whether they will be able to understand or interpret the implication of some of those PPP contractual clauses. In terms of PPP readiness in Africa, a couple of countries have PPP regulatory environments or enabling environments, but most of them do not have the regulatory environments, although they are going ahead to do public-private partnerships. So at the UNECE, I happen to be appointed as a vice chair, but I represent the whole of Africa. So after this conference, I intend to travel across Africa basically to understand the countries that have some enabling environment on PPPs, but also the countries that do not have any enabling environment on PPPs, basically to profile these countries and develop solutions on how best to help these countries in their infrastructure development and in their aspirations to bridge their infrastructure gap in their different countries. I have a lot to say about this topic, and I think for now, I beg to stop there. Thank you.
Thank you very much, Beatrice. I think that was a very helpful introduction to the broad range of issues and challenges. I'll move right away to Motoko if I can. And Motoko will give an overview of a number of developments and processes going on at the international level. Motoko, if you please.
Unmuted, please. Okay, can you hear me? I hope so.
Yes, we can.
Yes, thank you. Hello, everybody. First of all, thank you to IISD for including me in this webinar. With the next few slides, I'd like to discuss the latest developments in policy and law that influence the way in which PPPs are structured and documented. My view is that overall, as Howie said, there is a pretty profound lack of sufficient guidance on how countries can incorporate sustainable development considerations, both in terms of realizing public benefits and public good, and also in terms of mitigating risks. And that there is a lack of balance, shall we say, between the interests of investors and those of the state. But with that, let us get going, and let's look at the first slide. Next slide, please. Thank you. As Beatrice mentioned, we are all quite fixated on the infrastructure financing gap. So the most well-known estimate of the gap is by the Global Commission on the Economy and Climate, who predicted that we're going to need up to $90 trillion for infrastructure financing by the year 2030. The World Bank has predicted that we're going to need twice as much infrastructure spending. According to the Asian Development Bank, Asia alone needs $26 trillion. And the OECD said $6.3 trillion would be needed annually until 2030, that's annually. And we should add 10% for climate action. So those are significant numbers. Let's look at the next slide. So this is the latest forecast by the G20's Global Infrastructure Hub. They have an initiative called the Infrastructure Outlook, and they are predicting 97 trillion now. until the year 2040. And this is only based on data from 56 countries. So this amounts to $18 trillion in terms of investment gap. If you look below at 2019, we are estimating the investment need that takes also SDGs into account. That gap is at $3.3 trillion. The next slide, please. And this is just a breakdown of the infrastructure investment gap by region. You can see the significant amounts needed as well as the investment gap for each region, again, based on 56 countries. Thank you. Next slide. So the multilateral development banks have been asked to really increase their efforts to maximize private investments in infrastructure, including PPPs. And the MDBs have put forward this approach called maximizing finance for development. The screen is from the World Bank's program. It's a very snazzy program that you can see, video you can see right on the web here. But basically this approach is to entice the private sector and particularly institutional investors to make more investments in infrastructure. And so the approach asks us several questions in cascading manner. First of all, can a particular deal be financed by the private sector on commercial terms? If not, the World Bank will offer regulatory and policy reform to create an enabling environment for the private sector. If that's not enough, then the World Bank will try to help de-risk projects by offering financial products, offering blended finance, and so on and so forth to mitigate risks. And if that is still not enough, then the public sector financing option can be considered. So basically, I think it is quite striking that putting this approach puts public finance at the bottom of the cascade as a last resort. This is both problematic and unrealistic, considering that most infrastructure projects are currently publicly financed. Okay, next slide, please. Also, in order to address this infrastructure gap, the G20 has been doing, making all sorts of proposals and initiatives. And so this slide captures what the Argentinian G20 proposed at the end of last year. They focused a lot on standardization of infrastructure investment, and they actually came up with this idea that infrastructure should be offered as an asset class, just as much as investors invest in cash or in stock or in bonds. They should be able to invest in infrastructure just like that. The G20 promoted, among other things, securitization as a financial product that would be particularly suitable for institutional investors to make direct and indirect investments in infrastructure. The G20 also thought that governments have too much variation in terms of project preparation, from project appraisal to approval to implementation. So the G20 put forward principles for the project preparation phase, which are a bunch of principles which are very high-level principles, and I really don't understand how states can implement that, but that's something that came out directly from the G20 last year. And finally, they were very big on standardization of contracts, and this is really the topic of the rest of the webinar here. Okay, let's move on to the next slide. Thank you. So among other efforts, the G20, the OECD, and the World Bank did the stock take of tools and instruments related to infrastructure as an asset class. This was offered last summer. And basically they put together, they went through all the tools available from different institutions, and they put them into these categories that you see on the left-hand side of the screen, from project-related tool, policy-related tools, and then project-related. And at the bottom of project-related, they have a bunch of things that they offer. for transaction support and contract management. The next slide, please. And so if you zoom in right there, the stocktake found that there are instruments to promote more disclosure in PPPs. There's this World Bank Group guidance on PPP contractual provisions, which we'll come back to. And the Global Infrastructure Hub has offered this very detailed risk allocation matrices for different sectors. So all of these are available through the OECD document, which is available in turn in the resource part of the web link that we will provide later on. Next slide, please. Now, this is just some of the examples, even though the OECD effort counted about 90 initiatives, there are other initiatives ongoing. So let me just touch on those very briefly. The UN Commission on International Trade Law, that's UNCITRAL for short, is updating its quite outdated legislative guide on privately financed infrastructure. This is now to be called Model PPP Law. Because there are about 140 jurisdictions that offer PPP laws, I think that this initiative is very important. But unfortunately, there seems to be a fairly low-level stakeholder interest, particularly interest from states. And so this process has received very little attention to date. There is a submission that I made to UNCITRAL, which is also available as part of the resource document for this webinar. There are also two newish initiatives. The UN Economic Commission for Europe, UNECE, is also working on a model PPP law in collaboration with EBRD. And PIDA, which is the Program for Infrastructure Development in Africa, has a model law for infrastructure development, which I don't think is quite finalized yet, but I think it's very close. So these are something to keep an eye on in the future. The next slide, please. So because there are so many PPP laws, I wanted to understand exactly what they are offering in terms of sustainability content. And so in collaboration with the Monash University's International Economic Law Clinic, I did a study, a review of PPP laws of 18 sub-Saharan African countries. And this is just a very quick sum up of what we found, that laws generally fail to sufficiently mention sustainable development, relevant environmental and social standards and laws, community participation, or alignment with national development plans, even though there are obviously some good examples that exist. And so the pie chart down there just indicates the breakdown of the most frequently mentioned issues. The transparency issue comes up number one, but overall the percentage is very, very small. Thank you. The next slide, please. And so I would like to finish by quoting Vera Songwe, who is the Executive Secretary of the United Nations Economic Commission for Africa. She was the keynote speaker at the UNECE International Forum on PPPs just last month. And she mentioned very clearly, PPP contracts are heavily skewed against the contracting authorities. And I think this is a very serious observation that she made. And so we're going to try and unpack a little bit what this means. But just to sum up, all the countries in the world have signed up to the SDGs, the Paris Agreement. Most of them are signatories to international human rights treaties, multilateral environmental agreements. And yet these considerations are insufficiently reflected in legal instruments that support PPPs. There's just way too much emphasis on bankability and way too much interest in getting the regulatory environment attractive to the private sector. And this leads to contracts that not only lacks contracts that lack sustainability content, but also there is not a proper balance between state interests and investors' interest. And this is, I think, what Ms. Sangwe said, meant when she said PPP contracts are heavily skewed against contracting authorities. So with that, I will finish. Thank you very much.
Thank you very much, Motoko. And that's really a perfect way to end your opening comments and transition to Janice. Essentially, Janice will begin to explain why the current model of contracts that we see being promoted by organizations like the World Bank are so heavily skewed against contracting authorities of government. So with that heavy task set out for you, Janice, I turn it over to you.
Thank you very much, Howie. And thank you also, Motoko and Beatrice, for wonderful presentations. I assume you can all hear me.
Yes, we can.
Okay, thank you, Howie. Yes, it is a perfect segue into what my task is this morning to talk about, because using the World Bank guidance on PPP contractual provisions as an example of what Ms. Vera Sangwe has had to say about the way in which PPP's contracts are skewed against the government contracting authorities. The current version and really all iterations so far, the World Bank guidance are a perfect example of that. Can you change, new slide, please? So just to give a little bit of background as to how the World Bank guidance document has come about. The first iteration of it was a 2015 edition. Motoko gave a good overview of what the thinking of the bank was with regard to promulgating this document. One short phrase that's been used to describe it is billions to trillions, the concept of taking billions of dollars locked up in institutional investors and other investors in Western, in developed countries, and through development in infrastructure, turn that into trillions of dollars. The guidance documents focuses not on all aspects of PPP contracts, because as you can imagine, every PPP contract will have different business and operational parameters. So those types of things are very difficult to standardize, but the guidance document focuses on legal provisions of contracts, and we'll look at what those are in a moment, what those legal provisions are in the guidance. The guidance does not envision the government as a shareholder in the PPP. So in a way, calling these contractual provisions PPP provisions is a little bit misleading, because it's not really a partnership in the sense of joint ownership, certainly. There was subsequently a 2017 edition of the document. Our firm, as well as IISD, Observatory, the Heinrich Böll Foundation, did a lot, and other civil society groups did a lot of work on the version that was the 2017 version, pointing out the lack of balance between the contracting parties and the lack of content on sustainable development. We also engaged with the legal advisors to the World Bank for the guidance, very well-known law firm Allen and Overy. We had two very lengthy calls with them to discuss the specific provisions in the guidance document. And There is now a 2019 edition of the guidance. It was open for consultation from February to April of this year, but there was only one formal consultation in Singapore. There were no consultations in Africa or Latin America, but the government participants in the consultation that did take place ranked environmental and social risk as one of the top concerns. And we'll see how that plays out in the language that is in the guidance at this point. There were 3 new chapters added to the guidance, which I'll address later. And the document itself is expected to be submitted to the G20 summit that is currently unfolding in Japan. Next slide, please. This slide gives an overview, a listing, really, of the type of the contractual provisions that are included in the guidance. As to each one of these, the way the guidance document is structured, there is a multi-page narrative as on each topic, and then at the end of the chapter devoted to that topic, proposed draft language for actual provisions in the contracts. Looking at the right-hand column, the new provisions in the 2019 guidance that weren't in previous editions are the contracted authority step-in rights, handback of assets at a contract in, and let's see. Oh yes, a termination, an addition to the termination provisions. The stated objective of the guidance is to assist governments in emerging PPP markets with obtaining a better and more comprehensive understanding of provisions encountered in PPP contracts. Certainly, these type of provisions are encountered in PPP contract, but we will talk in detail about, or high level, about how this manifests itself in the guidance document. Next slide, please. There are the problematic features of the guidance at a high level view is that the guidance focuses on getting the PPP deal done quickly. And the word that's used over and over again in the guidance is bankability. The starting point of the provisions in the contract is one in which the starting point in the guidance provisions, particularly the sample drafting language, is what would constitute really in many instances the worst possible deal for the host government. And instead of giving a true balanced approach and options that could be that the parties could negotiate. Overall, the language places inordinate financial risk on the host government, and it inhibits the government's ability to regulate or otherwise act to address the environment, including climate change and social issues. Put bluntly, any post-execution event that costs the private investor anything falls on the government's shoulders, the cost of that. On paper, although it seems to put money in the investor's pocket, in that the provisions in these clauses are so skewed towards the private investor, but it creates huge contingent liabilities for the host government. And really, it results in the concept of bankability being a myth, because unsustainable PPPs lead to disputes. We know that. We've seen that over the last 30 years, in particular, with the ongoing investor-state disputes, some of which arise out of contracts, some out of treaties. It leads to disputes that take years to resolve And by years, I mean anywhere from 4 to 10 years to resolve. And even if an investor wins an arbitration or wins in a court, depending on what the contract provides for, sovereign assets are immune. And if the host government is not able or willing to pay the award or judgment, there's really very little for an investor to collect against. So entering into an unsustainable PPP is really the highest risk that an investor could take on. A truly useful guidance document would take a more balanced approach, where none of us have ever advocated for a document that's skewed in favor of the host governments. But what is needed is a more balanced contractual provisions that would advise on how risk and rewards can be fairly and, most importantly, sustainably allocated. The new provisions in the guidance, the ones that are new to the 2019 version, do provide a balanced approach. That it's not perfect, but it seems to be written by a different hand than the one that wrote the many other provisions that have been in the guidance since its inception, since the 2017 version, certainly, and really provide a template of the direction that the guidance document could go in. Next slide, please. And just to, I'm not going to spend a lot of time on this, but I want to take some sample provisions and give some flavor of specifically what the sample drafting problems in the sample drafting language. Force majeure events, there are events that are totally beyond the host government's control that constitute force majeure under these sample drafting language, and that trigger massive government payments. The same is true for the provisions that deal with material adverse government actions and changes in law. Basically, the private partner is insulated from the cost of complying with all subsequent legislation, even where there's no discrimination against the private partner, which is really contrary to the international law standard, which generally requires discrimination. And also protections from competition. They're treated as MAGA events, and there may be appropriate instances in which protection from competition would be appropriate, but there's no catering to instances in which there are monopolies, etc., that would need where the host government would need some flexibility. A good example of that is electricity or energy monopolies, where it would be impossible for the government to introduce renewable energy projects without triggering massive financial obligations to the private partner. Next slide, please. Also, problems with the transparency provisions in the PPP, in the World Bank guidance document sample drafting language, primary responsibility for transparency placed on the host government, and no real provision for ongoing disclosure of contract terms, contingent liability, performance information, and issues to do with environmental and social programs. A failure to address those items. Governing law and dispute resolution, I'll just focus for the moment on the provisions of the guidance document that provide for ICC arbitration. Nothing against ICC arbitration per se, but there is no transparency in that or any other type of commercial arbitration. And also there is no catering for where you would have an overlap of causes of action by the private investor under the contract, as well as under investment protection treaties. You might wind up with two separate dispute resolution proceedings that really deal with the same issue. Next slide, please. Just quickly to wrap up, what can be done to improve the guidance? We have made a number of our group has made a number of suggestions to the World Bank. We've submitted a document on April 30th containing a number of these, focusing on the points you see on your screen. With regard to these, adding a sustainable development chapter, the guidance document needs to explain the relationship between the environment and social impact assessments and PPP provisions, or updates or consequences on failures to comply with environmental and social impact assessments. Although there's some new language on climate change in the 2019 edition, it still places all of the cost on climate change on the host government. And the recommendation that we have made is that the World Bank delay promulgation of the guidance until these types of steps are taken to result in a balanced, really usable document for host governments. Next slide, please. And as a final point, what can country governments and civil society do? The most important thing is to take positions and speak out, and to speak to the people who are pushing the guidance and other initiatives that result in unbalanced, non-sustainable PPPs. There are some examples here of World Bank itself, the EDs at the World Bank, key government officials, and there is an increased movement towards intergovernmental regional initiatives, but much more is needed in that area to insist that the bank and others involved in this, the PPP, promoting PPPs, insist that they have meaningful consultations. And thinking outside the box, I have personally always thought that the education of potential investors in PPPs from the private sector was important regarding the risk of unbalanced, non-sustainable PPPs. I will wrap that up and turn the floor back over to Howie. Thank you all.
Thanks very much, Janice and Motoko and Beatrice. So we're going to open the webinar now to questions. For those who have questions, if you can find the chat function either at the bottom or top of your screen, all you have to do is click on chat, and then you'll see the message box open, and type your question into the message box, hit enter, and we should all be able to see the question. So if you have some questions, please do pick it up and start to do that. I'm just looking, I just got a chat now. Yes, for those, if you want to speak your question, you can do that also. We can unmute you. Just let us know you want to ask the question verbally instead of in writing. Well, while we're doing that, and those of you who wish to ask questions are preparing them, I wanted to ask a question about one other risk. That relates to the attractiveness of PPPs as a way of financing government procurement or government initiatives in what is said to be off-book financing. In other words, governments don't have to log those expenses as capital expenses. There is some concern that the types of contractual provisions that the World Bank has promoted would actually negate that opportunity by loading so much risk onto the government that ratings organizations and accounting firms would in fact look at that financing as on book and therefore creating credit risks to governments. I wonder, perhaps Motoko or Janice, if either of you could comment a little bit on that particular issue.
Thank you, Howie. This is Motoko. Maybe I can just get that started. Because a number of countries have had PPP binges in the past, and they have experienced a fairly significant macroeconomic crisis leading to austerity programs and suspension of social programs and so on and so forth. There is much more interest in getting countries to disclose these contingent liabilities that they take on. And in fact, a lot of countries offer all manners of financial inducements, from subsidies to guarantees to other measures. In fact, there's a long list of what countries can do, some of which are directly in order to motivated by the fact that these countries actually can do this off book, precisely as Howie mentioned. So as IMF and others push for more transparency in this area, and there are new tools that can expose countries taking on these additional debts, I think there is a potential risk that countries' credit rating could be impacted by how much debt they take on, how much contingent liabilities they take on because of PPPs. And there's also a lot of discussion about debt sustainability. This is one of the main topics coming out of the Japanese G20 that dealt with not only the quantity side of infrastructure investment, but also quality side. And so the G20 is expected to endorse these G20 principles on quality infrastructure investment. Debt sustainability is one of the key topics there. And so as there's going to be more interest in debt sustainability, I think countries are going to have to think twice about the kinds of inducements that they provide to the private sector. Thanks.
And this is Janice. I would just, that's a great overview, Motoko. And I would just add to that, everything that Motoko has just identified really argues, once again, for a holistic approach to PPPs. Typically, governments enter into negotiations for PPPs on a fairly isolated basis and not taken into account the overall financial impact on the country, and sometimes not even on the country's policies with regard to national development as a whole or that sector. Certainly the current pushing things on book has a major impact on that.
Okay, thank you both. Caroline Nagonzi has asked the first question in the chat, and I'll read it out. Thank you very much, Caroline, for this. It's a really critical question that cuts across a number of SDGs, although it also relates to specific ones. So she starts, thanks to all the panelists for this very informative webinar. I would like to hear your thoughts on the integration of gender into PPP contractual clauses as per the recently released primer by the IFC on gender equality, infrastructure, and PPPs. Beatrice, maybe you want to take a first crack at that, and then I'll give Motoko and Janice an opportunity. So I'll repeat the question. I would like to hear your thoughts on the integration of gender into PPP contractual clauses as per the recently released primer by the IFC on gender equality, infrastructure, and PPPs. Beatrice?
Oh, thank you so much for that question. In terms of gender and PPP's inclusion in the framework, that is a discussion that has not started. But as I do my work, I try to ensure that I take into account gender inclusion in PPP discussions, PPP structuring, and everything to do with PPPs. Even in my discussions at the UNECE, my colleagues there have picked it up. So we normally have sessions on infrastructure and the role of gender. Even the conference that I have, there's a specific session on the role of women in infrastructure development. But this is a discussion that needs to happen because when I was in Geneva, there was a lady from, I think, the World Bank. She launched a book, I think, on women or gender inclusion and infrastructure development. It's a discussion that needs to happen. But my challenge is all the issues you raised, presentation from Motoko, presentation from Janice, it's a very pertinent discussion. But why normally you find that these contracts are skewed, or the financing arrangements are skewed, or the structuring of these projects are skewed? It's because of capacity. I take you back to capacity. Because most of the government institutions, the government officials, they do not understand what you're talking about. When I was a director at the PPP unit, under the Ministry of Finance, there is the debt department. You talk about the debt ceiling. You talk about debt sustainability. This department did not understand when government contracts these loans, the implication of these loans on the debt ceiling. And now when you talk about PPPs and government is talking of getting the DFIs in and the different financing arrangements for these PPP projects, the department was kind of incapacitated. They cannot understand the complexity surrounding some of these financing arrangements. So it goes back to capacities. If you look at the legal section in government that is responsible for advising government on these contractual arrangements, they barely can't understand what those skewed clauses that you have, because we had a challenge just to draft the regulations for PPPs. Drafting the regulations for PPPs, which I think is something which is would not be very hard. They said we cannot draft these regulations because PPPs is quite a new thing, and this is a whole ministry in government that is responsible for advising government on everything legal. So I think in addressing, I'm running away from the question now, in addressing the issues that you say, what must we do? I think we should go back to capacity. If we can help these governments, especially in Africa, in understanding exactly what are PPPs and how should these projects be structured. First of all, for government to get money, value, but also to bring the private sector to account for whatever it is supposed to do. Because in Uganda, we have developed what we call the transparency, disclosure, and accountability framework. So why this framework was developed is because in the past, the different kind of projects we have entered into as public-private partnerships, you find that the private sector was insulated from disclosing anything. So there's one of the private sector players who is actually in the electricity sector, who the public was viewing as extorting a lot of value from the population. So now the population was demanding the private sector to disclose what is the rate, what is the tariff, what is the price at which you charge a unit of electricity. Of course, there's a regulatory authority, but the public wanted the private sector to declare, but the private sector said, no, I am not supposed to declare anything to you. I'm only responsible to the private sector, to the regulatory authority. So the public went up in arms and said, no, we need you to disclose. We need you to disclose. And that now demanded for or resulted in the development of the transparency, disclosure, and accountability framework. And this framework is double-edged. Both the government has to disclose, and both the private sector has to disclose. And it defines areas maybe where the private sector may not disclose, but now they have opened it up. The private sector has to disclose by all means, and there are certain aspects of the disclosure that they have to do. So I'm sorry to run away from the question, but I think I tried to cover what you presented. Thank you.
No, I think that's very helpful, Beatrice. I just let me come back to the gender, and then we'll come back to the capacity issues that you raised, as well as a couple of other questions that have been asked. So Motoko or Janice, anything in particular, any other issues in particular to reply to the question on gender and the inclusion of gender, reflecting gender issues in the contractual provisions?
Well, I would just add quickly that to Beatrice's comment that you know, with the unbalanced provisions, of course, the host government is going to wind up paying for any introduction of gender-based requirements, for example, that impact in a regulatory manner, for example, the private party. And that money, that contingent liability and actual liability, if the government imposes those types of requirements or regulations later, or even at the contracting phase. If it's an unbalanced provision and it all falls on the shoulders of the government to bear that cost, then that takes away from that discourages governments from making those requirements. And also, to the extent it does, it takes money away from other social programs.
Howie, this is Motoko. Let me just add very, very quickly. So Beatrice is absolutely right that gender is a question of inclusivity, and there are both benefits, the risk element and the opportunity element. So the risk side is the failure of the project to control, for example, sexual violence against women and children by laborers and construction camps, for example. It's a subject of the World Bank's inspection panel investigation. Or lack of safety in transportation that results in women being endangered in trains and buses, right? So those are risks that are associated with projects. There are also reputational risks. On the other hand, if a transportation plan does not adequately take into account the transportation patterns of women, which is totally different from men's, then women may not end up utilizing that transportation as much, which is actually a bottom line issue, that the project may end up having less revenue because women are staying away from using public transport. And so there are both risks and opportunities issues that must be addressed. And Janice is absolutely right that this needs to be addressed at the feasibility study level, at the project design level, at the environmental and social impact assessment level, and also in contracts. So it should be addressed throughout the life cycle of the project. Thank you.
Thanks, Motoko. I'm going to leave those issues, or the issue of gender, there for a minute. I do want to come back on the capacity issue, and then I'm going to come to 2 out of the 3 questions that we have on the chat now, and then the 3rd question come back to after. Beatrice, I totally understand and 100% agree with your comments in terms of government capacity issues. One of the concerns, though, that we have, and one of the reasons for hosting this webinar, is that some of the key institutions that are, in theory at least, helping to try to fill that gap, that capacity gap for developing country governments, institutions like UNCITRAL at the UN, with their model contract and model laws, PETA, and critically the World Bank model contract clauses, they're supposed to help fill those gaps, and there's no lack of capacity in those organizations. Yet what they are producing, as we've talked about earlier, is very, very skewed in and of itself. It lacks balance. It lacks a reflection of sustainable development. They lack a clear understanding in many cases of the very kinds of capacities governments need. So I think the issue, in a sense, is multiplied because of that. You have the lack of capacity by many of the African and other developing countries, and those institutions that are supposed to help fill that gap are doing so in a largely imbalanced way now, making it even more difficult for developing country governments to be able to respond to contract proposals or other initiatives, other negotiating contexts. So I think I totally agree with you, but the problem actually is multiplied now, I think. Mm-hmm. And with that, I wanted to just go to the two other questions for this issue, one by Maria Cuervo, who asks, I would like to know if there are key spaces where civil society could advocate for more transparent PPPs and PPP negotiating processes, both at the regional level or globally. So that's the first one. And a related question, one of the problems about this is understanding the language. All the documents, training, information are in English. What can we do about that? So those two questions that relate to inputs, engagement, and so on, and transparency in the process. Maybe Janice, you could start with that, and then we'll go to Beatrice.
Okay, I think Beatrice and Motoko are better to speak to the key spaces where civil society could advocate, but as far as exactly what groups are out there and what would be more effective, because both of them work much more on the regional level than I do. As far as the language issue, sorry, I don't mean to sound so cynical, but as far as the World Bank guidance, I'm not even sure, other than these 3 new provisions that were added to the most recent version, I'm not even sure the document merits being translated into other languages. But I would say that I would imagine that some of the documents that are in the cloud and that have been referenced in our discussion today do exist in more than just English, to the extent they're being put out by organizations like the United Nations or like the World Bank. But I would say perhaps an insistence on these organizations putting their documents into other languages, or assistance from the governments themselves if there are internal translators. I'm sorry, that may sound like others may have better ideas about how the document could be put into the local language instead of just English.
Okay, thanks, Janice. Beatrice?
Please, can you assist me repeat the question again?
Yes, there are 2 questions. I would like to know if there are key spaces where civil society could advocate for more transparent PPPs and PPP negotiating processes, both at the regional level or globally. So that's one question. And the second one concerned the fact that the documents are generally, international documents are generally only available in English. Is there anything that can be done to improve that situation, make them available in more languages?
Thank you for stepping in to clarify. I would start with the last one. Translating these documents to local languages, in my view, might distort what you want to put across, because there are certain words in PPPs that you may not actually be able to translate directly to the language you want to translate. And in the process, you might distort what you want to put across. For example, if you're talking about a partial risk guarantee, I don't know how you put a partial risk guarantee like in my language. I don't know what word is equivalent to a partial risk guarantee, or in Chinese, I don't know. If you talk about viability gap funding, if you talk about blended financing, if you're talking about a financing structure, if you go into a force majeure, I don't know, in my view, we had a discussion like this before. In my view, if we try to translate some of this PPP like a legal document or a feasibility study, a feasibility study that has been translated is likely to mean something else than the actual feasibility study. That's my view from where I sit. When you go into the civil society, the spaces they can fit in PPP, maybe disclosure or preparation, it's a lot. Because civil society, I believe in the PPP space, just like the space they play in other forums, they have a role to play. If you look at the onset when they're conceiving a project, sometimes in my government or in other African governments, the project is not conceived in a systematic way or in a way that you expect the project to be conceived. So a civil society can come in and say, but I think there's something that is missing in this space. Why don't you do X, Y, Z as the law? Because they have access to the law, they have access to the policy. They should be informed, first of all, they should be informed, and they should have capacity to understand what the process of conceiving a PPP project or the PPP process up to the end, to financial close, to implementation and everything. And if they understand the process, then they can always interject at whatever stage, either at feasibility study or at the time of procurement, because sometimes that's where there are problems. At the time of procurement, you find that maybe not the right private sector has not been selected. So the civil society at that point should be able to understand, oh, if somebody is supposed to be appointed, what must that person have? Or if somebody is supposed to be a key player in maybe in the road construction or in the hydropower plant construction, what are the requirements? So they must know the requirements such that they can raise their voices at the right time, but they also raise the right questions, because it's not good to just make noise when you don't actually know why you're making noise for. But if they know what is required at each phase, they would be very useful instruments, especially in louding up some of the anomalies. If it is from the private sector point of view, they can raise it. If it is the World Bank guidance material, or if it is a World Bank contractual clauses, if it is a PPP, maybe a feasibility study guidance that has been given, or it is a project facilitation fund, maybe the fund has not been used to fund a specific project which could have been brought value to the government. If the civil society is informed on what project should be done as a PPP or what is involved in a feasibility study, I believe they would have a lot of value addition in this process, because all the issues we are raising, you're mentioning about the skewed PPP, contractual clauses, the focus on bankability and all these things. Why they continue persisting like that is because the civil society does not understand these aspects of bankability and when to raise these questions. Because the moment they raise these questions, you find that most often, both the government, the private sector players, and whatever institution, whether it is World Bank, IFC, whatever it is, they all stop whatever they are doing and they want to listen to what the civil society is saying. So it goes back to what I was saying is capacity. Capacity both in government, capacity in the private sector, capacity for the civil society to understand what goes around in the PPP space. That's what I would say.
Good. Thank you very much, Beatrice. I think that's a very comprehensive approach to a number of the issues. The last question that we have, and we have just about 2 or 3 minutes left in our time here, I'll ask specifically to Motoko. This goes back to a number of issues of business and human rights, business conduct generally. The question is from Merdad Asadpour. To what extent can CSR, corporate social responsibility, be helpful in respect of investor obligations in PPP contracts? Is it enough, let me just embellish the question a little bit if I may, is it enough to just reference CSR or corporate social responsibility? Do we need to go beyond that and have specific obligations? Is it enough just to rely on domestic law as it is at any given time? How do we treat that issue in terms of ensuring appropriate investor obligations? So I'll put that one to you, Motoko, and if you can take perhaps at most 2 minutes, and then I'll give each panelist 1 more minute for a final comment and we'll wrap up. So Motoko, please.
Sorry, I was on mute. Thank you for that very interesting question, Merdad. I think it could be a subject of a book. So I'm not sure that I can really summarize this in 2 minutes, except to say, in infrastructure, when private sector is participating in infrastructure financing and operation, basically that private sector company is taking on a traditionally public sector responsibility. And so therein, I think, lies the problem and also a distinction between the infrastructure, say, and the extractive sector. So I think that just, first of all, relying or counting on the private partner to exercise their CSR program in the infrastructure context, I don't think is enough. I think ideally the detailed outcomes of the environmental, social, human rights, climate, whatever impact assessment should summarize what the private sector obligations should be, and that should be covenanted appropriately in the PPP contract. And Howie also asked, is compliance with domestic law enough, or compliance with certain international standards enough? I think that that will depend on country law, the international standards, but ideally, the situation should demand a very comprehensive review of available standards as well as international law. A lot of these issues are already addressed in international law, and some are appropriate for the private sector. And so the parties should really spend a lot of time thinking about their rights and obligations that should be reflected in the PPP contract, taking into account this is an endeavor to provide public service. Thank you.
Thank you, Motoko. That was an excellent summary. Let me just add to that. In one of the earliest arbitrations relating to infrastructure, one of the earliest international arbitrations was against Tanzania following the privatization of the water system in Dar. And in the arbitration award, it was noted that the company itself, in that case, Bywater Gulf, a joint venture between German and British companies, they on their website had said that they were providing a public service relating to an essential human right. In other words, they were in the provision of ensuring human rights are achieved. And that was actually taken into account by the tribunal itself in terms of the standard of care the company had to commit to. And in this case, didn't achieve. So these issues are relevant as we go forward, and there is a place for them in both the contracts and in subsequent disputes. Charles has sent, Charles Afeku, hi Charles, has sent a comment. People for whom the project is supposed to benefit deserve to understand it in their language. This is about the language of translation, arguing basically that there needs to be more functionality in language. And I think there's two issues here. One is translating the documents into English, from English into French and Spanish and Portuguese. In other words, other principal languages, which we still don't have in most cases. And then the issue of local languages. And there, I think Charles' main point, we need to close, Charles, so forgive me for summarizing, but I think Charles' main point is if we want to have engagement from local communities, the documentation has to be in language they can understand. And I think that's a very important point. Even if it's imperfect, it's better to have at least some useful communication in the local languages than none. So that I think is Charles' point. With that, I'll go back to Janice, if you have one more closing comment, please, and then give the final word to Beatrice. Janice?
I guess my closing comment would be with regard to PPPs is for civil society and governments to look for opportunities to get people in to do training or to hire, because this really runs to Beatrice's many excellent comments about capacity, to really ferret out opportunities for training, long and short-term training on PPPs, the whole process of contracting, and the macro impact as well as the micro impact of PPPs. I don't think there's any substitute for it, and sharing of that information and technology transfer, I think would be enormously important to making the whole world of universe of PPPs a more viable one.
Thank you very much. And finally, Beatrice, one final minute.
Thank you so much. First of all, I want to appreciate you for thinking about me and inviting me for this very wonderful and insightful discussion. And I am honored and privileged to be part of the panel. And just to give my final remarks, I thank you for those insights, especially the obvious skewed legal documents that normally we see in our countries. But you know, when you're given something by the World Bank, sometimes you can't do anything. From one side, you know that maybe the document is not good, but on your own, you can't do much. I would just want to share with you that at the UNECE, we came up with what we call the People First principles in support of the UN Sustainable Development Goals. And the intention of these People First principles, as the word mentions, is as we do infrastructure projects, we must focus on people first. We are saying that listen to the people. What do the people want in terms of infrastructure? And all the issues we have been mentioning, are the agreements skewed to one party or not? So we need to make sure that the people are involved. And then also we should do smaller projects that basically can be used also by the poor, because most of these big projects are in urban areas that normally the poor people do not have access to. And the other one is de-risk the projects and make sure that the projects have minimal risk as much as possible. But then it comes back to transparency and disclosure, both for the private party and both for the government, and so that everybody knows what is going on inside there. We have a lot to talk in PPPs, but I think in my summary words, just to thank you for considering me as one of the panelists for this event. And I look forward to future engagements in these discussions around PPPs. And I also would like to invite you all to Kampala in September to attend the high-level event and bring those discussions now in Kampala, and we can have a very vibrant discussion on what we have done today in Kampala. 16th to 18th of September, Kampala is a place to be. You're all welcome.
Thank you so much, Beatrice. I think that's a great way to end the discussion today, noting that there are opportunities for follow-up, and certainly on behalf of ISD, we will be engaging with you on that meeting, that very, very important meeting with Janice and others at Foley Hoag and Motoko, of course. To all of you who have participated thank you so much for taking your time to do so. And the video will be available before long, and the PowerPoint will also be available for everybody before too long. So thank you to everyone. Have a good rest of your day, and we look forward to having another opportunity to speak to you about these critical issues. Thank you very much, everyone.
Thank you too.
Howard.
Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye.
Everyone.